this other stream started, and see if you guys can hear me, see if you can see me, and we need to switch the camera. Yeah, there we go. Hang on. Yeah, you want to hide that? There we go. All right, so let me know if you guys can hear me. Let me know if you can see me. And we'll go from there. Funny enough, I'm seeing a commercial on on my own stream, trying to figure out what you guys see. So, all right. Okay, Nick can hear me. That's nice. So once again, I'm Andrei Mincov, founder of Trademark Factory. Really excited to have you over on this stream. The way we're going to do this is in the beginning, I will talk about something very important that just happened in the US with the USPTO canceling over 5,000 trademarks. There's actually a lot more, but we're going to talk about this last instance when they killed 5,500 trademark applications. And that's a big deal, obviously. So I will walk you through the details of that. And after that, after we've talked about this, and by the way, I'm happy to answer questions about that as well. But once we're done with that part of the stream, I'll do what I've been doing, is I'll answer anybody's questions about anything, about whether it's about trademarks, whether it's about intellectual property in general, whether it's about entrepreneurship, whether it's about me, whether it's like really anything you want to ask me. That's your opportunity to do that. So, and with that in mind, I'm once again really happy to welcome you on this stream. And I'm going to jump to my computer to share some stuff that just happened with the USPTO. So let's do that. All right. So hopefully you can still hear me. And all right. So let's talk about this. The USPTO is the Trademarks office in the US, obviously, and they have been really rigid about their rules lately because they're seeing a huge avalanche of new trademark applications coming. And if you think about it, it used to be 500,000 a year, then it became 600,000 a year, then it became 700,000 a year. And they're noticing that a lot of those trademark applications are not as high quality as they used to be. So they started panicking because obviously that takes up a lot of resources from them. And they're also noticing that some applications are filed by these cheap online filing services that don't do it right. And really something we've been warning people about all this time. And now they've finally taken the next step and they canceled people's trademarks. And I will provide my feedback about what I think, whether it was the right decision or wrong decision in that sense. But let's quickly go through. So I'm going to walk you through two documents. One will be a blog that USPTO wrote about what they're doing to prevent fraud on the Trademarks office. And again, as I go through that, I'll provide my comments. And then we'll also go through this final decision that killed 5,500 trademarks. So let's do that. So so what they're saying is businesses at home and abroad are becoming more and more aware of the value and benefits of a U.S. trademark registration, which is true, right? And they see this historic surge of new trademark filings over the past year, and they're seeing an increase in suspicious submissions ranging from inaccurate to fraudulent. And they've analyzed a snapshot of data between October of 2019 and April of 2020 and found that they need to do something about it. And what they're noticing is that this rise in fraudulent trademark filings and trademark-related scams has driven them to implement new strategies and tactics to intensify our attack against those who would seek to undermine the value and legitimacy of this important intellectual property right. A change of approach, which USPTO embarked on several years ago, was necessary to confront an unprecedented threat, one that is coming among industries dealing with the scourge of counterfeits, fakes, illicit trade, and even piracy. So they believe that the best way to fight trademark application fraud and scams and to aggressively safeguard their trademark register is to pivot to a comprehensive brand protection type strategy, and starting last fall that they did just that. So they say that they've experienced a 40% increase in trademark applications over the past year, which is massive, right? They've never had a spike that high, and they're noticing that the increase is driven by a number of factors during the pandemic, including the growth of cross-border e-commerce, foreign government subsidies, and tremendous rise in new business formation. We've noticed that as well with Trademark Factory. 2021 was by far our best year ever, right? So when you think that with all the lockdowns and stuff, the business activity would fall because, you know, of the uncertainty, just the contrary, right? A lot of business owners, a lot of people who used to be employees who got fired, who found themselves unemployable, you know, whatever the reasons, a lot of them finally gave themselves permission to start their own business, and they wanted to do it the right way, which includes, of course, protecting their brand. But in addition to those legitimate trademark applications, also there was a lot of other things happening. So here's what this blog continues. There's thousands of foreign manufacturers that want to sell directly to U.S. consumers have been told that they need a U.S. registered trademark for their products, correctly, to receive priority position on e-commerce sales platforms. That's correct. So, and they say, even though this is not necessarily true, this phenomenon has spawned new low-cost filing mills, multinational scams, and even created a secondary market for buying and selling U.S. trademark registrations. So when they say, even though this is not necessarily true, so what's not necessarily true is that you can get your brand on, for example, Amazon brand registry, even without a U.S. trademark registration. So if you are, let's say, UK-based business, you can get a UK trademark and still get that on Amazon. And because it's faster to get your trademark registered in the UK, that's what a lot of business owners do. But if you're planning to sell your products to US consumers, you definitely do want to have your brand trademarked, because you don't want to put your products out on the market where you don't own the brand. Okay, and here they go after all these low-cost trademark filing companies. So they say, as a result, low-cost trademark filing companies claiming to specialize in the acquisition of U.S. trademarks have aggressively been marketing their services to potential and unsuspecting clients. Most foreign manufacturers and sellers have little or no experience with U.S. trademark laws and registration procedures, so they don't know whether or not these services are legitimate. And this is really why we've been seeing this, of course, as well, and I've been mocking the $69 trademark registration companies for years. We've even published a book, and this one thing I forgot to do for this for this stream is to create an easy way for you to see the link. So Nick, I know you're helping me in the chat. If you could get the link to our 7 Red Flags book. So it's trademarkfactory.com/7-red-flags. If you could put that in the chat, that'd be great. You can download that book absolutely for free. And if you were wondering what that gift was that I promised in the email, to those of you who received the email to be on this chat, that's really my gift to you. It explains the dangers of what those cheap online filing services do to steal your business, really, and leave you out in the cold when things get complicated. And so today, this part of the stream, we're going to know exactly what they did. It's absolutely mind-boggling what they did to their clients. So where did I leave it? Okay, so conversely, many foreign agents are aware of the USPTO rules, yet try to find ways to circumvent them. For example, they hijack the credentials of attorneys licensed in the U.S., or they enter into relationships with questionable U.S. attorneys who rubber stamp whatever paperwork they provide. The U.S. trademark registration system has historically relied upon the good faith intentions of its customers and their counsel. These illicit operators, however, are trying to game the system in order to illegally obtain U.S. registrations. Traditionally, our examining attorneys have been on the front lines of this fight, but conducting investigations instead of examinations only does a disservice to legitimate applicants seeking trademark registrations. And this is also what we're noticing, is that what used to take 3-4 months for initial examination now is close to 9 months in the US because of all the backlog. They also say that the examination process does not always efficiently lend itself to discovering wider patterns of fraud and improper behavior that often taints many applications at a time, right? Because multiple applications are often filed by a single entity using the same data elements but owned by multiple applicants. It is by tracking those common data points through our IT systems that we identify and fight back against these schemes. To achieve this result on the scale we need, in 2019, they created and are now expanding a special task force of attorneys, analysts, cyber investigators, and IT personnel to investigate submissions that they suspect are violating U.S. rules of practice, representation rules, or USPTO's terms of use. Right? So the USPTO does not have law enforcement capability, but they leverage what they do have, the ability to enforce their rules against those seeking to circumvent them. Really, in light of all of this, they launched a bunch of investigations, and they figured out a way to stop their trademarks. Right? So they say for those suspected of violating the USPTO rules, they issue show cause orders requiring them to establish that their filings and behavior are legitimate. And if they respond inadequately, or if they find that applications were filed with intent to circumvent their rules, they will issue a final order for sanctions, including terminating the tainted applications and blocking the filer's access to their trademark system. Additionally, they're creating their database security through login, identity authentication, and role-based access controls. Doing so will help prevent bad actors from submitting any future applications, right? And so that's where we are. So let me walk you through that the actual thing that happened just recently, and it is this order, and it's just one of several that they've launched and finalized recently. And it's, like I said, it's pretty mind-boggling. So I'm not going to read through the whole thing because it's a lot of legalese here, but I'm just going to point out some stuff here. So in a show cause order, right, and this is, again, something that they mentioned in that blog, is when USPTO finds something that they are suspicious about, right, they issue a show cause order that basically goes something like this. Prove to us that you are not trying to scam the USPTO. And if you respond to it and show that, no, you're legitimate, you're using a proper attorney, or you're actually filing this trademark yourself if you're a US resident, if you can prove to them with evidence, then they're like, okay, that's fine. But if you don't respond to that order, then they have the authority to investigate this further. And that's exactly what happened here. So they issued this order in November of 2021, and they informed this company, AppTech Ltd, 360 Digital Marketing LLC and RetroCube LLC. They asked them to show evidence indicating that they engaged in an egregious scheme to deceive and defraud both the USPTO and individual applicants in more than 5,500 trademark applications, including engaging in the unauthorized practice of law and intentionally providing false, fictitious, or fraudulent information to the USPTO in violation of the USPTO's rules of practice. They were ordered to show cause why those sanctions should not be imposed and answer 4 requests for information. They were supposed to respond by November 17th. They didn't respond, and so here is the final order. So they say they've got the authority to sanction those who are in violation. So here's what they did. And if you think that this is something unique and outrageous, think again, because a lot of the companies mentioned here and were widely advertised on Google, widely advertised on other platforms, and all they do is they promise to file your trademark for $69, $49, $99, whatever the price is, one of those companies that did that, the website, was actually called Trademark Falcon. The reason I remember specifically that one is because we had a bunch of people go to us when they were still operating. Now they're not accepting new applications. But I remember pretty well, some discussions where unsuspecting brand owners would try to convince me and my team that a trademark filed through Trademark Falcon is just as good as a trademark that would be filed through Trademark Factory. And as much as we tried to explain to them, convince them that that's not what they're going to get, that they're getting themselves in a really bad deal, some of them decided to go with Trademark Falcon, and now all their trademarks are dead. As much as I don't want this to be an "I told you so" moment, that's exactly what it is, right? I'm not gloating. I'm really, really sorry for those brand owners having lost their time and their money. Most importantly, time, because they didn't lose a lot of money, even though the government fees, it still adds up. But it's the time that they lost, and someone could have jumped into the trademarks office after, filed a proper trademark for the same brand, and guess what? Now that those cheap trademarks are dead, the other person's trademark may go through. So that's really the biggest problem. Again, I will provide my comments about whether USPTO did the right thing when they killed these applications or not in a moment. But let's quickly go through this and see what happened. So respondents, these companies, operate dozens of websites offering logo design services and low-cost assistance, filing U.S. trademark applications. The websites hold themselves out as individual U.S.-based companies, though each website is in reality under the primary control of Abtec, a company in Pakistan, presently under investigation by Pakistan's Federal Investigation Agency for Criminal Fraud. Respondents would solicit parties interested in applying for a trademark registration by touting falsely low fees and timeframes to obtain registration. So if you read that book that we're sharing, so again, trademarkfactory.com/7-red-flags. It's exactly what we're saying, right? Deceptively low fees and those promises, hey, you're going to get your trademark registered in 5 minutes or less, 15 minutes, like all this bullshit, because trademarking process will take you over a year in the US, about 4 years in Canada now. And so whenever somebody's promising you that you're going to get your trademark registered or you're going to get your brand trademarked in a couple of minutes, run. Run as quickly as you can. Okay. Also, they were doing deceptive practices to coerce their logo design customers into allowing them to file U.S. trademark applications on their customers' behalf. In certain cases, respondents would send customers false yet official-looking letters bearing the actual seal of the USPTO, threatening customers with legal action if they fail to register their logos with the USPTO within a particular time period. These fake demand letters, misappropriating the USPTO name, logo, and seal, scared customers into paying for unnecessary services that respondents were not even permitted to undertake because respondents are not a law firm, nor do they employ licensed attorneys to prosecute U.S. trademark applications. So in the U.S., you can only file the U.S. trademark application in two cases. One, if you're filing a trademark for yourself or for your own company, assuming that you are resident in the U.S. The other possibility, when you're not a resident, or when you're trying to file a trademark for somebody other than you or your own company, you must use a U.S. licensed attorney, right? It doesn't matter how much you know about trademarks, doesn't matter how well you understand the process, you gotta use a U.S. licensed attorney if you're not filing a trademark for yourself or if you're not a resident filing for your own trademark. So respondents, these bad guys, provided customers who hired respondents to file trademark applications with falsified application filing receipts and invoices for inflated fees. Respondents charged customers filing fees for multiple classes of goods and services, while in reality, respondents only paid the USPTO for single class applications, often including a different identification of goods and services than those agreed to by the applicant. Now, this is just fraud. This is just criminal. So actually, to go back to using U.S. licensed attorneys, right? So we're a company based in Canada, right? We can't file U.S. applications directly, and we don't. So what we do, we kind of act as the interface between the client and the U.S. attorney, who then does all the representation between themselves and the USPTO. So all the trademarks that we file properly through the U.S. licensed attorney. They don't rubber stamp anything. They work with us and make sure that everything that's being filed is filed correctly. And so going back to the multiple classes, when you file a trademark in the U.S., well, really anywhere, one of the things that you got to put in your trademark application is a list of goods and services for which you're planning to protect your brand, right? And those goods and services fall under one or more classes of goods and services. Class is basically a category, a bucket. There are 45 of them. I have a whole video that explains classes in more detail. And there's a filing fee that depends on how many classes you're filing in. Some countries have the same amount for each class. Like, for example, in the U.S., it's $350 per class if you're filing with T Standard, which is the platform that we recommend. In Canada, there's one fee for the first class, and then the lower fee for every class after that. But either way, the government filing fees are based on how many classes you're filing in. And what these guys did is they said, well, let's file your trademark for, in 3 classes. So in the USPTO, like in the US, if you're looking at that, so 350 times 3 is 1,050. So they take that in government fees, and they only pay USPTO 350, right? And they pocket the difference. Absolutely horrible. Funny enough, so what we did, we used to have a different system in how we used to file, pay government fees on behalf of clients. We used to ask, the client's credit card, we just use that, and it worked on a small scale. But then as we started growing, we realized that was becoming unsustainable. Just, getting those credit card details, ensuring that they're stored properly, wasn't really making a lot of sense. So the decision that we made is we take the government fees from the clients. They pay us in order for us to pay through the attorney. And what we ended up doing, we ended up eating the merchant fees on that because we didn't want our clients to pay a penny more than what they would have paid had they worked with the USPTO directly. So that just shows you the difference, right? Some people, take your money for classes they don't file in. What we do is we eat the money, eat the cost, the 3% on the one hand, and also when we're, paying the attorney, that's another thing. So, okay, so let's go through that further. Respondents hid their improper conduct from their customers by providing a false email address for the owner in the application, an email that was actually controlled by respondents to intercept all communications from the USPTO. Respondents would then make material changes to USPTO correspondence before forwarding it to their customers. Filing receipts were modified by respondents to make it seem like additional classes were included in applications and multiple class fees were paid to the USPTO when that was not the case. So it's, like I said, absolutely criminal. Again, when you're not filing a trademark through an attorney, right, then you're deemed to be filing a trademark yourself. And that's what we mean by your trademark is not going to have an attorney of record. So when you don't have an attorney of record for your trademark application, your contact details must be yours. They can't be somebody else's. So you can't have a third party acting on your behalf if that third party is not an attorney in you're dealing with the USPTO. And they didn't have that. So when you do have an attorney, the attorney controls it. But again, just to show you the difference, how they did it, how we do it, very different. So we have a client cabinet where everything is super transparent. You have the link to your trademark application that you can always see what happens to it in the Trademarks Office database. So if USPTO issues a document, you can see it straight there. Basically, we have daily systems that we see updates when something happens to your trademark application. We update on our end, you get an update. So super transparent compared to what these guys are doing. This is really interesting. Respondents intentionally filed applications with errors to cause the USPTO to issue an office action, creating unnecessary delay in prosecution of the applications. Like the filing receipts, respondents would intercept notice of the office actions, make material changes to create artificial issues, and then forward the modified office actions to their customers. Okay. Sorry, guys. Let me turn this off and mute it. There we go. All right. Where was I? Yeah, so they would make material changes to create artificial issues and then forward the modified office actions to their customers in order to charge the customer additional fees to respond to the office actions. And at all times, respondents had no authority to practice before the office and were not permitted to communicate with the office on applicants' behalf or counsel trademark applicants regarding their rights. Right? So this is really bad, because what they're doing is not only are they buying time, they're also creating those problems to extract more money from brand owners who didn't know any better. Respondents filed thousands of submissions through USPTO.gov accounts and impermissibly shared access to these accounts with multiple users who all filed submissions. They were not authorized to, so some technical stuff that they did. And then in many cases, whether the initial application or the response to an office action, respondents improperly entered the signature of the named signatory on declarations explicitly stating that false statements and the like are punishable by a fine or imprisonment. And then it goes to, so it basically said what they did, and here are the sanctions. In determining the sanctions, USPTO considers many factors, and here they see that respondents are engaged in a widespread, intentional, coordinated effort to defraud both applicants and the USPTO by providing false, fictitious, and fraudulent information. So they say that they've engaged in the unauthorized practice of law, have been involved in filing submissions in more than 5,500 trademark matters before the USPTO. Many such submissions contain impermissibly entered signatures, all contain false correspondence information and application information, different from what the actual applicants intended to be filed, such as identifications of goods and services that are material to the issuance of a trademark registration. And respondents could not reasonably or in good faith have believed that their actions before the USPTO were proper or permissible. So, they go through all of this, and they say that respondents' actions have caused and continue to cause immeasurable harm to thousands of applicants. Very true. Through their improper conduct, respondents have caused unnecessary delay and increased the cost of proceedings before the office, while simultaneously eroding trust in the U.S. trademark registration process. Continued reports of misuse of USPTO insignia and misrepresentations of these proceedings to respondents' customers suggests that respondents' bad acts are continuing. So here's what they do. They terminate all submissions filed by respondents. They say it was willful. They knowingly did what they did, and the conduct infected thousands of applications, resulted in false and fraudulent submissions, and adversely affected the integrity of the federal trademark registration process. While individual applicants were likely unaware of the nature and scope of respondents' misconduct, well, even though, again, we try to educate people as much as we can only do so much, right? So there's only so much we can do, and you can't really educate someone who's not willing to listen. If you believe that you can get quality legal services for a process that's going to take on average a year and a half, and you expect those quality legal services rendered to you for $99, I'm sorry, you're an idiot. I really can't say anything better than that, because it just is not how it works. And really, most people are not idiots, right? The reason they go with those companies is because they don't realize what actually goes into the trademarking process. They don't realize it's long. They don't realize it's actually something that involves a lot of legal knowledge, a lot of experience, and they think that it's just as easy as getting a domain name. Just a different form of a domain name, right? You get a domain name for $9 and you get a trademark for $99. No. So very different, very, very, very different. And so, like I said, we do whatever we can to convince and educate, but still individual applicants, were likely unaware of the nature and scope of respondents' misconduct, the acts and omissions of a representative who files documents with the USPTO, including a representative not authorized under USPTO rules. And so USPTO and the public rely on the truth and accuracy of the contents of documents. Facts in the applications were false. Often the goods and services authorized by the applicants were not those identified by respondents in the submitted applications. In each case, the email address identified as belonging to the applicants in the filed applications were those of the respondents. And again, the rules are different when you file for yourself or when you file through an attorney, right? Because obviously attorneys want to make sure that USPTO corresponds with them, doesn't go straight to the applicant. That's the reason applicants hire people, so that they take care of their work. But that wasn't the case here, because none of these respondents were attorneys of record. Additionally, most applications were supported by verifications or declarations that were not signed by a proper person, and the signatures were not personally entered by the named signatory, rendering them invalid. None of these submissions may be relied upon to support or maintain registration, and therefore may not be given any weight. Additionally, applications and any post-registration submissions filed by respondents are fatally defective because they are supported by invalid verifications and declarations and involved fraud on the USPTO. So a trademark registration obtained by fraud is not valid, and under the facts presented, the applications and any post-registration filings are effectively void, and the defect cannot be cured. It does not benefit the applicants, registrants, or the USPTO to devote time and resources to further examining applications or post-registration filings known to have such fatal defects. All right, and so yeah, basically they kill all trademarks, pending trademarks, registered trademarks, all of them, 5,500 trademarks dead, all applications. Right, and they're going to list them. I'm going to show you just quickly. They also say that respondents can't operate in the U.S. anymore, and that's the end of the story. So that's, these are all the trademarks, like pages and pages and pages and pages and pages and pages of trademarks that USPTO killed. And there, right? So we can go through this, and each of these trademarks, really that's what pisses me off the most. Each of these trademarks has a story behind it, has a hopeful business owner behind it who thought that they were doing the right thing, who thought that they could get their brand protected, who thought that they would have, a trademark in the end of the day. They paid the government fees, oftentimes inflated government fees. They paid these guys whatever they charged them, and they got nothing to show for it. So I'm going to go back to the other camera now, and let's talk a little bit about this, and then we'll take questions. So there we go. The real problem here, the way I see it, is well, of course, right? You shouldn't use firms that are trying to lie to you. That's not a good idea. And if anyone says that they will trademark your brand for $200, they're lying to you. They're lying to you through, in your face, because that's not how it works. Filing a trademark is easy, right? You can file a trademark for $200. You can have an attorney file your trademark for $200 if they're not really doing any due diligence, and you just tell them what to file. But anything beyond that, the office actions, the going back and forth with the trademarks office, the evidence of use, all of that, right? It takes time. It takes attorney time. It takes time from people who've been doing this for years and years and years and years, and their time costs something. So again, anyone who genuinely thinks that they can get their brand trademarked through an attorney for $99, $199 is just delusional. Now, and then I understand that USPTO is trying to crack down on these people, and they're right. They should be, especially if they're doing criminal stuff, right? I mean, I'm as free market as it gets. I'd love to live in a world that doesn't have any licensing rules, that doesn't have any regulation, none of this crap. imposed by bureaucrats, I really don't think that it benefits anybody. The one thing that, as the free market guy that I am, that I find super important is that if you want to compete, that's fine. If you want to, offer your services for $99, that's fine. But you have to explain to people what your services actually cover and don't cover. Once you do that, I don't have a problem, right? So obviously with Trademark Factory, you're going to pay us a lot more than $99 when you file your trademark through us, and the reason we charge more is because we can show you what that number actually covers, right? And the reason it's so frustrating when some good business owners, some smart people go with the $99 services is that because they believe that they're getting essentially the same thing through those other companies, which they don't. So going back to what the USPTO did, so they want to crack down on those low-cost trademark filing mills, the way they call them, and we call them, cheap online filing services. So almost same terminology, and they realized that anyone can start a website, right? This company was from Pakistan. Anyone can start a company. Anyone can put on a website with a form that will ask you for your brand, for your name, and for your money. They can find ways to file your trademark properly or improperly, well, in their case, improperly, and then disappear into the night. And USPTO obviously doesn't want that because they want to make sure that their register contains properly registered trademarks. So they tried it one way, the other way. They tried to punish the bad actors. And in this case, they said enough is enough. We're just going to kill the trademark applications. I'm kind of torn on this. I'm really torn on this decision because I don't know if it actually accomplishes what the USPTO wanted to accomplish. Because if these firms had any ethics, had any morals, had really given a shit about their clients, yes, in that case, if trademarks that were filed through them were killed, they would find it morally necessary for them to figure out a way to make their clients whole, to make sure that they refile their trademarks properly, to that they do whatever it takes to ensure that the clients who use their services ended up getting something. But that would only work for firms that are not criminals. In this case, you have the opposite effect, right? So the fact that they killed 5,500 trademark applications, the trademark owners, it's their problem because the trademark falcons and all of those websites, they're not going to do anything, right? They're just going to go back to Pakistan and maybe build another website and start a new LTD, LLC, or whatever. And so the only people really suffering from this are the brand owners. And I wish that the USPTO gave them really an opportunity to save their applications. Do something, right? They would probably have to pay somebody to save their application and maybe prove what they intended to do. But at least give them an opportunity to do something with their application that they didn't have any control over. So again, I think the measure of killing the actual trademark application is the most extreme measure that the USPTO can take when it sees that some rules were not followed. rules may be not followed by mistake, rules may not be followed intentionally, and rules may not be followed with a criminal intent. USPTO has a whole range of things that they can do about that. And like I said, the most extreme thing they can do is just kill the trademark application. And the real question is, did they accomplish what they wanted, right? Because yeah, okay, they killed 5,500 trademark applications. There's still a bunch of those low-cost filing services out there, right? And if you go to Google and you know and try to Google, you know, file cheap trademarks, you'll still see a ton of them out there. People who were likely to use Trademark Falcon and all those other companies are just as equally likely to find any other company, trademark something, you know, that would that would end up exactly the same way, right? They're just not educated enough about it, and that's the problem. So again, I don't know if killing those trademark applications was the right thing to do. Probably if I were in the USPTO shoes for this, I would create some sort of a procedure that would allow brand owners to somehow prove that the trademark was filed in their name, and give them an opportunity to somehow save it, to somehow save that. And you know, that's not what happened. It's not the only final decision that USPTO made. There's another one with some Chinese company. I think it was like 15,000 trademarks that got killed. So it's absolutely nuts. And so USPTO just keeps going. And so the reality for the people who file their trademarks through these companies and who got killed, they got nothing, right? They don't get a refund from the USPTO. They don't get a refund from the company because, well, go find them. And worst of all, they don't even have a pending application anymore. So let's say you filed your trademark in 2019 through one of those companies, and you were the first in line with your brand, let's say. And so it gets examined. There may be an office action that these guys fabricated. So it goes on and on. It, you know, drags on. And let's say somebody else may have filed a similar application in 2021. And so their application was suspended pending the resolution of your own, of your application that you filed a while ago. And so now that the earlier application is killed, the new application by somebody else will go through. So the original owner will not be able to go back and claim, hey, I was there first, because to the USPTO, their earlier application doesn't exist. It's dead. And that's the worst part about it. That's the saddest part about it, because there's nothing at this point they can do. So if you open any of those applications that got killed, it just says it is invalidated and it's dead. That's it. Case closed. So that's first part of the stream that I wanted to dedicate to this situation when the USPTO canceled 5,500 trademarks recently. And if there are any questions on that, happy to answer them. And if there are any questions on something else, I'm happy to answer those questions as well. So let's see what we can do about this. And I'll stay on for as long as we still have people asking questions, like I've done twice before. Actually, you know what? Here's a question. So we decided to do these lives every 2 weeks, every Thursday, and pretty much randomly we picked this time at 4 p.m. Pacific. I'm wondering what you guys think of the time, if we get enough people to If we get enough people to ask for a different time, we may consider switching it. But again, put it in the chat, and we'll go from there. So let's go through the substantive questions, and I'll answer them as they appear on the screen. All right, so there's this delay. So I'm waiting for the question to show up on the screen, and once it's there, there we go. Okay, so rodless reel. Can you trademark acronyms that represent something? For example, EDP, everyday players, or something like that. That's a great question. Funny you should ask this. When I was still attending my first law school back in Russia, and I had a trademarks class in trademark law. That was the first question that I asked about acronyms, and because it's fascinating. You can do different things with acronyms, and the answer I got there made sense, and it still makes sense, and it makes sense regardless of jurisdiction where you're in, whether it's Russia, US, Canada, doesn't matter. So the answer is this. The Trademarks Office will examine the abbreviation for the same way they examine any other mark. They examine it how it sounds like, what it looks like, and what it means. And if they find that by looking at how it sounds like, what it means, and how it looks like, if they decide that it's too close to something that's already there, you're going to have a problem. And if they decide that it's generic, they'll also say that it's a problem. So for example, I couldn't start a phone company and call it A.P.P.L.E. You know, so just because you make something into an abbreviation doesn't by itself mean that you've got a separate brand. Or you cannot take a generic word, put dots in between, or make it all capital, and assume that the Trademarks Office is going to say, oh yeah, we get that. So, you know, you're selling, you don't sell pencils, you sell, you know, PE and so on. No, of course not. So they look at that. Also, when you've got an abbreviation that that doesn't represent a known word, then they would all often ask you, what does it stand for? And they also want to know whether the abbreviation is a term commonly used in your industry, and like USB, for example, right? And then of course you couldn't trademark that, so that's the thing. So for example, you know, EDP, if you're filing EDP, the trademarks examiner may ask you, so what does EDP stand for? And then they say, well, everyday players, and then they would potentially run a search on that, but generally, yes, you can trademark acronyms. You can trademark acronyms that represent something. So for example, going back to my Apple example with the dots. So if you were to come up with something that has a meaning, you know, I'm probably not going to be able to come up with something meaningful on the spot. But if you actually created a phrase for what, you know, APPLE stands for, then you potentially could get away with that, right? So again, I'm not going to even try now to come up with what that could stand for. But if all you did is just put that as a phrase that has the first letters as Apple, you might be able to get away with that. But as soon as you start marketing this so that people can read it as Apple, Apple will go after you and win. So again, just use your common sense. Just because you have dots in between, just because you put big letters, doesn't is not enough of a change if what you're doing is obviously trying to rip somebody off. So don't do that. And that, I think, is the answer to the first question. So let's move on to the next one. Yeah, so let's wait for that to change in the screen, and we're gonna go from there. See, this delay is killing me. I don't know what to do. All right, so there we go. Question from Peep. I contacted Facebook regarding copycat branding with our registered brand, and they wouldn't do anything. It's total brand confusion with our customers. Can anyone on social media just have whatever they want? Yes and no. More likely no than yes. The real question is, how far will social media companies go to help you protect your brand? And that differs. That varies really quite a bit. Instagram, we've had people who got their trademark and were able to easily take a username that was registered by someone else. We had people who weren't able to do that. So there is no guarantee that if you have a trademark, then you will be able to get those platforms to automatically give it to you. But surely you have a better chance compared to when you don't have a trademark. So when people reach out to us on Instagram, often, we get those messages, probably, 2-3 messages like this every day. Like, hey, could I get a trademark because I'm really interested in getting this username on Instagram? I always say, if your only reason for wanting to trademark your brand is to go for the username on Instagram, don't. Or at least don't use us, because that's not a good enough reason to get a trademark, right? If you don't have products, services that you feel are gonna grow, that you're going to have a business that's going to be at least, 6 figures 2-3 years from now, then you don't really have a business that really needs a trademark. There are situations when there are exceptions to that rule, when you're a nonprofit, when you are building something more long-term, stuff like that. But generally, you only do trademarks when there's something that you're hoping that's going to be bigger than just getting an Instagram username. But again, the other reason I say that is because even if you do get a trademark, there's no guarantee that IG is going to give it to you. Sometimes they do, sometimes they don't. Same with Facebook, same with Amazon, same with pretty much, YouTube and Twitter. We've had things go one way or the other. But the important thing is this: once you've got a court order that says that Facebook has to give you the profile, then they will comply. So they've got a lot of discretion how they treat this, when all it is, like, you fill out the form on Facebook's website, say, this is the brand, this is the page that I'm not happy with, this is my trademark registration number in this country, please take it down or please give it to me. They've got some discretion looking at this, and like I said, it could go either way. But once you've got the court order, so if you go to court and actually enforce your trademark against those other people, that says that you are the rightful owner of this brand, and this other company that currently has the profile page on Facebook, they are not allowed to use your brand, that they're infringing on your trademark. If you can prove that, then you can show this to Facebook, and at that point they don't have a discretion, they have to enforce that. So, you know, it's just really how far you need to go to prove to Facebook that you should be the rightful owner of whatever profile. So I hope that answers the question. And well, we're just going to go to the next one from here. All right, what do we got? Got a question from Tomer. I'm probably messing up your name. Tomer Shemish. I filed a trademark for my company over the lockdown, but have a limited budget. Do you think we need to file another trademark for the logo before we launch, or would we be fine to launch without one and file for the logo once we have a cash flow? Great question. So really depends on how important the logo is for you growing your business and attracting customers. The name is the most important brand element you can trademark, because if you can't own the name, if you don't own the name, you know, whatever logo you've got, you don't own that either. So it all starts with a name. And sometimes you can file what's called a combined mark when you have both the name and the image in the same trademark. But what you've done is the right thing. So you file for the name. So assuming that it's going through, that it will register, it may have registered already. Now you're building the business knowing that you own the name. That's the exact right thing to do. And from there, you can build on, right? You can look at other jurisdictions. You can look at logos. You can look at taglines. You can look at, you know, filing all sorts of things. At that point, really, it becomes more of a choice than a necessity. Because when you're starting a business, there's no point. There's no reason in the world to spend a minute of your life or $1 out of your pocket building a brand you don't own. Once you secured the name, from there, everything is gravy, right? And again, there are companies where the logo is the business, right? If you think of Apple or Nike logos, right? They're so recognizable that it'd be crazy for them to not own it, right? So that would be the thing that you would do really early on. If your logo is just of some, you know, or, you know, Coca-Cola is another example, just, you know, classic. But if you're not there, if you think that, you know, you may be able to change your logo and not lose any business if you were to change your logo, you know, a year from now, then yeah, take your time, make sure that you've got a business that can pay for a trademark, and then just go with that. All right, let's go to the next question. Do we have a next question? Okay, Al Siciliano. If you file for more products than you actually use, do you need to file again to add or remove the other products? If you file for more products than you actually use. Okay, so the use concept only really exists in the US. So in the US, your trademark will not register until you have shown to the USPTO that you have use for all the products and services that you're filing for. You can file a trademark before you start using. It's called an intent to use application, and that's absolutely fine. It may be approved, may be allowed by the Trademarks Office, but it won't be registered until you give them photographs, screenshots, links that prove that, hey, we are now selling all these products. And there are ways when you can split and allow a trademark application, for example, if you've got use for some products and services, you can split it, let it go to registration, and keep the remaining goods and services in a child application where you continue to ask for extensions of time to show that use to the government. So that's what happens in the US. In most countries, you actually don't need to prove use. So in Canada, it's no longer the rule. So you can file for whatever the hell you want, and they will register your trademark. And then the way that you can lose that if you're not using your trademark for all those products and services is anyone may raise their hand and request cancellation of your trademark, whether partial or complete, based on you not being able to show that at the time that they requested you to prove that you use your products and services for all, that use your trademark for all the products and services listed in your trademark application. If you don't have that, that will be removed from your trademark. So, and going back to this question, right? So if you've got more more products, you can, like I said, wait until you can prove that you have use. You can remove products you no longer need in your trademark. So for example, you file your trademark for, I don't know, accounting services, pencils, and rubber ducks, right? And this is the example I use in the course that I teach, learn.trademarkfactory.com. And we're actually showing some promo codes where you can get that at 75% off if you're interested. So the example, the pencils, accounting services, and rubber ducks. So you file your trademark, and then you realize that, you know what, I will probably continue to offer my accounting services. I might sell pencils, but I probably won't be selling rubber ducks under that brand. So nothing stops you from deleting the rubber ducks from your trademark application, class 28, if I believe correctly, and just keep everything else. So that's the second possibility. And the other part of your question, you cannot add. So if you file your trademark for rubber ducks, pencils, and accounting services, if a year later you realize, darn, I really want to, in addition to all of this, I really want to sell refrigerators under my brand, that you'll have to file a new trademark application. You cannot add more. You cannot expand more. You can't even expand within the same class. So for example, if you file your trademark in class 25 for apparel, and you say you're going to be selling shirts and you're going to be selling hats, right? If at some point you decide that you will also start selling shoes, you will have to file a new trademark application, even though shoes and shirts and hats are all in the same class 25. So I hope that answers this question, and we'll see what else we got. So I'm hoping you guys are finding this useful, and actually put us in the chat if you enjoy the stream, and if what I'm doing is actually helpful. And we're going to go to the next question. So I'm hoping you guys are finding this useful, and actually put us in the chat if you enjoy the stream, and what I'm doing is actually helpful. And we're going to go to the next question. So, all right. So I am assuming we're done with the questions for this one. And if there are any last moment questions, feel free to ask. Like I said, it doesn't have to necessarily be about trademarks. It can be about trademarks, can be about other types of intellectual property, can be about entrepreneurship, Canadian lockdowns, really whatever you want to ask about Trademark Factory, happy to answer them. And if we've got nothing else, then we'll just end this stream and be back in 2 weeks and go from there. So just to give you a little bit more before I wrap this up. So I mentioned the course, Trademarks for Growth-Minded Entrepreneurs. I put together over 6.5 hours worth of content. I think it's the best piece of content I've ever put together. Right, I've got over 800 videos on YouTube with specific things, but I've never created something as systematic as the course that I put together. And if you use the promo code YTLive at learn.trademarkfactory.com, you're welcome to get that with a 75% off. I'm really not making any money on this course. I just want to make sure that people who get it are invested enough in going through it. So that's one thing. The other thing is anyone who is interested in getting their brand trademarked with a guaranteed result for a guaranteed budget, which is what Trademark Factory does uniquely, you're welcome to go to trademarkfactory.com/YTLive and book a call with one of our strategy advisors. They'll help you. They'll answer all your questions, and they'll help you get started if you feel there is a good fit. And if you mentioned that you came from this YouTube Live or any other YouTube Live, really, just mention that, and they'll give you a 10% off. And finally, if you know somebody who you think should have a brand trademarked, or maybe you know someone whose trademark got killed through one of those cheap trademark filing services that I talked about in the earlier part of this stream, if you know someone who is trying to build something, they're hoping they have a big dream for their business and the big dream for their brand, and if you know that they haven't trademarked it, send them our way, and as a thank you for you sending them our way, if you register as our affiliate, we're going to give you $500. So we actually have multiple ways that you can take advantage of this as our affiliate. So go to affiliate.trademarkfactory.com. You can have affiliate links. You can send people directly and then let us know that who you sent to us. If you don't feel like for example, if a friend comes over to you and says, and you realize that they need a brand, I realize that it's not going to be proper for you to say, well, you know what, I got this affiliate link, use that so I can get $500. But what you could do is you could just tell them, hey, go check out Trademark Factory, and if you give us their name and they ended up end up becoming our clients, we'll just honor that and attribute that to your affiliate account. And if you don't want to make $500 yourself, you just want to pass it on to your friends, that's another possibility. So you can, at that point, actually do give them an affiliate link that will, instead of you getting the $500 affiliate commission, just give them an additional $500 off. So, it's something we've just launched 2 days ago, the new version of the affiliate program. I'm really excited about it. So if you know someone, and I'm sure everyone on this channel knows people who have a business, who have a brand that needs to be trademarked, send them our way. So that's the way you do it. So affiliate.trademarkfactory.com for the affiliate program, learn.trademarkfactory.com for the course if you're interested in learning about trademarks, and if you're actually interested in getting stuff done for you by properly licensed attorneys with one flat fee that covers everything from start to finish with a 100% money back guarantee, then you just go to trademarkfactory.com/YTLive, and that will give you 10% off your order. So that's what I got for you today. I thank you all for showing up today. I hope you found this useful, and I'll see you in 2 weeks. And until then, I'll see you in 2 weeks. I already said that. All right, so let's shut it off.